function. After I finished composing the amended complaint, I discovered more disturbing factual allegations. This information is being added to this video. Plaintiff looked at some of the documents in Chris Van Hollen v. United States Federal Election Commission Case No. 1:11CV00766 and other similar cases. The following observations were made. The summons in a civil action does not bear a seal. Year 2011. It is allegedly signed by MAUREEN Higgins. This is the same person who signed the void summonses in Citizens United v. FEC, a case that was filed by simulation in the year 2007. Christopher Shays and Martin Meehan 1:06CV01247 FEC, 2006, also bears the same signature along with other cases listed in subsequent paragraphs. The name of the server on the proof of service is Christopher W. Carrion, a managing attorney at Wilmer, Cutler, Pickering, Hale and Dorr LLP, 399 Park Avenue, New York, 10022 and an alleged attorney in said case. Therefore, even if the summonses were proper and they were not, he could not have served them. When looking at the signature of Roger M. Whitten, bar number 163,261, it bears a similar resemblance to the one used by Clayton J. Callan, found on all three of the proof of service for the return of summonses for Citizens United. In addition, the printed handwriting on all the documents found on the civil cover sheets and return of services are tremendously similar. The civil cover sheets all contain numerous types of the same text boxes. These text boxes are unique as they are rectangular boxes composed of small circles. The subsection of section I which states attorneys, if known, are all covered with the text box that contains the judge's information. They also contain the printed case number in the right-hand corner that is written in the same person's hand, the same type of circular mark, numbers, 1, 2 or 3 on the right-hand corner at the end of the first page, etc. These documents were allegedly filed. It is hard to know if the documents were actually filed as there is no document ID on these documents. Therefore, the alleged file stamps could have been generated by MAUREEN Higgins or other non-defendants co-conspirators. After comparing all of the numerous documents and knowing that the conspirators need the help of the court clerks to engage in the factually alleged allegations, a reasonable person would assume that it was MAUREEN Higgins, the deputy clerk for the D.C. court that is filling out the service of process forms that pertain to the Federal Election Commission, statutes regarding voting rights, etc. When the similarities are brought to a person of average intelligence, they can see that they were filled out by the same person. Additionally, they are all in paper, not electronic form. What are the odds of the same deputy clerk signing and processing all these simulated cases from approximately 2006 to 2014 and maybe later? Defendant Brinbaum owns most if not all of the process-serving companies in the state of Illinois and throughout the United States. If a summons is not properly issued by the clerk of the court, it cannot be served. The defendants who are officers of the court are fully aware that when the clerk issues a summons they often fail to sign it and or place a seal on it. Therefore, they know the summons are invalid and cannot be served. Yet, they serve them anyways. You would be hard-pressed to find an attorney who filed a valid appearance form. The courts are fully aware that they have no legal right to foreclose or incarcerate anyone when laws and rules are not followed, but they do it anyway. An attorney appearance must be made prior to or simultaneously with the filing of any document. This means any document that was filed by an attorney who did not follow the above rules is void without legal effect. Any alleged orders that were given even by the U.S. Supreme Court are void without legal effect. When the officers of the court criticize other governments, literally declares war on them and invades their countries, putting it mildly, it is like calling the kettle black. I am not defending other countries who engage in the same alleged criminal activities. However, the actions of some of the corporate and government defendants are beyond vile. When the government participates in these activities, they are no better than a hitman. A reasonable person would assume that anyone who engages in such criminal activities is devoid of a conscience and enjoys inflicting pain on others. Time and time again our young soldiers have gone to war to protect what the world assumes is a democratic government. Countless numbers of these soldiers paid with their lives for a fair and just government. Some of the same soldiers who survived the wars have also been victims of this vast network of corruption because hundreds of thousands have lost their homes. In total contrast, a majority of the corporate executives own numerous multi-million-dollar homes. I have come to the realization that nothing is as it seems. Hence, on information and belief, some of these lawsuits are only initiated to strip people of their civil rights and for corporate greed. A vast number of these state and federal officials hold the title of Your Honor. A person is required to rise when they walk in a room. I find this title disturbing because there is nothing honorable in the foregoing factual allegations made in this document and all other documents that I have submitted to both the State Court, Illinois Supreme Court, the Judicial Council and the Illinois Northern District Court. On information and belief, justice will not be served in the George Floyd and Ahmaud Arbery cases. As shown in the Stephen Avery and Brendan Dassey cases, this is because an appearance of counsel along with a certificate in addition to service of process will probably not be made with the full knowledge of the courts and law enforcement. All of the officers of the court know that the clerk of the court cannot fill out and sign documents for litigants. All knew or should have known that they were committing fraud. All of the above demonstrates that the clerk of courts, judges and attorneys are allegedly involved in fraudulent activities to the highest level. In addition, it further supports the fact that D.C. District Court and the U.S. Supreme Court never had jurisdiction to hear said cases. Wherefore, plaintiff demands that the officers of the court, the banks, and other corporations stop the factually alleged looting and stealing of all Americans' property and homes. The next video shows the full 2-page cover sheets and some other documents.